Formats Appendix A. Plaint. In the City Civil Court at Hyderabad, Civil Suit number 100 of 2002. Rajnikant Ramprasad Pandya, Hindu, adult, that is plaintiff, aged about 50 years, residing at so-and-so address versus Raman Bhai Mohan Bhai, Hindu, adult, age dash defendant, about 55 years, residing at 35 dash Hyderabad. The plaintiff above named humbly states as under 1. That by an agreement in writing dated 1st January 2000, signed by the defendant contracted to sell to the plaintiff his bungalow, referred to in the said agreement, hereinafter called the said property, the suit property, for 10 lakhs. The amount of 1 lakh was paid by the plaintiff to the defendant as earnest money at the time of agreement. 2. The plaintiff was ready and willing to perform his part of the contract, and on 1st June 2001, he tendered 9 lakhs, the balance of consideration, to the defendant and called upon him to execute a sale deed, but the defendant refused to do so. 3. The plaintiff has always been and is still ready and willing to perform his part of the contract by paying the balance of purchase price to the defendant. 4. The cause of action for the suit arose on 1st January 2001 when the defendant executed the agreement to sell the suit property to the plaintiff, and on 1st June 2001 when the plaintiff tendered the balance amount to the defendant and showed his readiness and willingness to perform his part of the contract, but the defendant refused to execute the sale deed and thereby failed to perform his part of the contract. Fifth para. The cause of action arose in Hyderabad because the agreement was made in Hyderabad. The suit property is situated in Hyderabad, and the defendant also resides in Hyderabad within the jurisdiction of this court, and this court has therefore jurisdiction to try this suit. Para 6. The value of the subject matter of the suit for the purpose of jurisdiction as well as the court fee is 10 lakhs. 7. The plaintiff therefore prays A. that the defendant may be ordered to transfer the suit property by executing a sale deed in favor of the plaintiff. 2. That in the alternative, the defendant may be ordered to refund the plaintiff an amount of 1 lakh paid as earnest money and also pay 9 lakhs as damages for committing breach of the contract. C. The defendant may be ordered to pay the plaintiff's cost of this suit. D. That such further or other relief as the nature of the case may require may also be granted. Para 8. The description of the suit property is given in the schedule annexed to this plaint. ABC, plaintiff's advocate, verification, plaintiff signed, verification I. So and so, the plaintiff above named do solemnly declare that what is stated in para 1 to 4 is true to my knowledge, and that what is stated in the remaining paras is stated on the information received by me, and I believe it to be true. Signed by plaintiff. Schedule. Description of the suit property. Bungalow number so-and-so, known as so-and-so villa, situated at so-and-so, Hyderabad. The boundaries of the suit property are to the east so-and-so, to the west so-and-so, to the north so-and-so, and south so-and-so. Strictly speaking, this prayer is not necessary. Next. Appendix B, written statement. In the City Civil Court at Hyderabad, Civil Suit 100 of 2002, Hindu, adult aged 50, residing at so-and-so area, Hyderabad, plaintiff versus Hindu, adult age 55, residing at Hyderabad, defendant. Written statement on behalf of the defendant above named. 1. Para 1. The defendant denies that he entered into an agreement to sell the suit property to the plaintiff on 1st January or any other date, and that the plaintiff paid 1 lakh or any other amount to him as earnest money as alleged in para 1 of the plaint. 2. The defendant denies that on 1st June or any other date the plaintiff tendered 9 lakhs or any other amount to him and called upon him to execute the sale deed as alleged in para 2 of the plaint. The defendant says that since it is not true that he executed any agreement to sell the suit property to the plaintiff, the question of the plaintiff tendering the balance of consideration and the plaintiff being ready and willing to perform his part of the alleged contract did not arise at all, and the whole story is got up and false. 3. The defendant says that in view of what is stated above, the plaintiff has no cause of action to file the suit against him. 4. The defendant therefore submits that the plaintiff is not entitled to any of the reliefs claimed by him in the plaint, and the suit filed by him be dismissed with cause. Signed by defendant's advocate. Next, appendices verification. I, so-and-so, the defendant above named, do solemnly declare that what is stated in para 1 and 2 is true to my knowledge, and what is stated in the remaining paras is stated in information received by me, and I believe it to be true. Signed by defendant. Next, Appendix C, issues. In the City Civil Court at Hyderabad, suit number 100/2002, so-and-so 15-address plaintiff versus so-and-so 55-address defendant. Issues. The following issues were framed at Exhibit 15. 1. Whether the plaintiff proves that the defendant entered into an agreement to sell suit property to him for 10 lakhs. 2. Whether the plaintiff proves that he paid a sum of 1 lakh as earnest money to the defendant. 3. Whether the plaintiff proves that he was and is ready and willing to perform his part of the contract. 4. Whether the defendant proves that the case of plaintiff is totally false and got up. 5. To what relief, if any, the plaintiff is entitled to. 6. What order and decree. My findings are as under: 1. In the affirmative, 2. In the affirmative, 3. In the affirmative, 4. In the negative, 5 as per final order, and 6 as per final order. These are the issues. Now Appendix D, first appeal. In the City Civil Court at so-and-so, Mr. So-and-so 35, so-and-so area, appellant, originally defendant, versus Mr. So-and-so 55-area, respondent, originally plaintiff. Appeal under Section 96 of the CPC 1908, claim 10 lakh, the appellant above named must respectively state as under: 1. That the plaintiff respondent filed a suit in the City Civil Court at Ahmedabad, being civil suit number 100/92, against the defendant appellant for specific performance of the contract alleged to have entered into by him with the defendant. In the alternative, the plaintiff prayed for damages of 10 lakh from the defendant, alleging that the defendant had committed breach of contract. 2. That the learned judge, by his judgment dated 13 January 2003, decreed the suit filed with the plaintiff for specific performance of the contract and ordered the defendant to execute a sale deed in favor of the plaintiff. 3. That being aggrieved by the decree passed by the learned judge, appellant herein begs to prefer its appeal on the following among other grounds. Grounds 1. That the learned judge has erred in decreeing the suit for specific performance filed by the plaintiff, that the learned judge ought to have dismissed the suit for specific performance filed by the plaintiff. 3. That the learned judge has erred in holding that the defendant has entered an agreement to sell his bungalow to the plaintiff. 4. That the learned judge ought to have held that it was not proved by the plaintiff that the defendant had entered into an agreement of sale with him. 5. That the learned judge ought to have held that since no agreement was entered into between the parties, there was no question of showing readiness or willingness to perform the alleged contract at all. 6. That the learned judge has erred in holding that the plaintiff had paid 1 lakh to the defendant on 1st January 2001 as alleged by him. 7. That the learned judge ought to have held that the plaintiff did not pay 1 lakh or any part thereof to the defendant on 1st January 2001 or any day. 8. The learned judge had erred in holding that the plaintiff tendered 9 lakh to the defendant on 1st June as alleged by him. 9. That the learned judge ought to have held that the plaintiff did not tender 9 lakh or any part thereof on 1st June or any day to the defendant as alleged. 10. That the learned judge has erred in holding that the defendant had committed a breach of contract as alleged by the plaintiff. 11. That the learned judge ought to have held that when the plaintiff did not enter into an agreement with the defendant, there was no question of breach of contract by him. 12. That the learned judge has erred in ordering the defendant to execute a sale deed in favor of plaintiff. 13. That the learned judge ought not to have granted specific performance of the contract by ordering the defendant to execute a sale deed in favor of the plaintiff. 14. That the judgment and decree passed by the learned judge is otherwise also contrary to law, against the weight of evidence and against the principles of justice, equity, and good conscience. For the appellant, therefore, prays that the decree passed by the learned judge in civil suit number 100 may kindly be set aside and the suit filed by the plaintiff may be dismissed with cause. And for this act of kindness, the appellant shall be in duty bound forever pray. So-and-so, Hyderabad, date so-and-so, signed advocate for the appellant. Appendix F, second appeal. In the High Court of Gujarat, in the High Court of Telangana, Hyderabad, district, so-and-so, second appeal number so-and-so. So-and-so 17, address so-and-so, appellant, originally defendant versus so-and-so, character so-and-so, originally plaintiff. Appeal under section 100 of the CPC 1908, claim rupees 300. The appellant above named most respectively states as under 1. That the plaintiff appellant filed a suit on the court of the civil judge, being the regular civil suit number so-and-so, so-and-so of 2000 against the defendant respondent for a declaration that the order terminating the service of the plaintiff passed by the defendant on 25th June 2000 was illegal, otherwise discriminatory, contrary to law, or penal in nature and therefore inoperative, and for permanent injunction restrain the defendant and or his servants, agents or nominees from implementing or executing the said order, and also for an order directing the defendant to reinstate plaintiff in service and will with full back wages and other consequential benefits. 2. That the learned judge by his judgment and decree dated 15 July 2001 dismissed the said suit filed by the plaintiff holding. Since the plaintiff was a temporary servant, he had no right to hold the post, and the defendant had the power to terminate his services and order was therefore legal and valid. 3. That being agreed by the decree passed by the trial court, appellant, plaintiff, preferred an appeal in the court of the district judge, being the civil regular appeal number so and so. 4. That the learned district judge by his judgment and decree dated 27 December dismiss the said appeal filed by the appellant and confirm the decree of the trial court. 5. That being agreed by the decree passed by the trial court and affirmed by the lower appellate court, the appellant above named begs to prefer an appeal on this honorable court, that is High Court. In this second appeal, among others, the following substantive questions of law arise for determination of this honorable court. 1. Whether facts and circumstances of the case courts will have committed an error of law in dismissing the suit filed by the plaintiff. 2. Whether in the facts and circumstances of the case the courts below have committed an error of law in holding that the order terminating the services of the plaintiff was illegal and valid. 3. Whether in facts and circumstances of the case the courts below have committed an error of law in holding that the plaintiff was merely a temporary employee and had no right to hold the post. 4. Whether in facts and circumstances of the case the courts below have committed an error of law in holding that the order terminating the services of the plaintiff was not punitive in nature. 5. Whether in the facts and circumstances of the case the courts below have committed an error of law in holding that the plaintiff was not entitled to invoke protection of Article 311(2) of the Constitution of India. 6. On the grounds stated above and on the grounds which may be urged at the time of hearing, it is prayed that this appeal may be allowed in the decree passed by the civil judge so-and-so 165 of 2000 and confirmed by the district judge so-and-so 198 of 2001 may be set aside and the suit of the plaintiff be decreed with cause all throughout. And for this act of kindness, the appellant shall, as in duty bound, forever pray. At the Hyderabad, date so-and-so, signed Advocate for Appellant, after Amendment Act of 1976 in the CPC, now second appeal can be filed only on the ground of substantial question of law. Strictly speaking, this cannot be said to be a substantial question of law, but normally, in the memorandum of second appeal, such question is raised by the advocates. Next, revision Appendix F. In the High Court, so-and-so Hyderabad, District Judge so-and-so, revision number 76 of 2003. So-and-so near address so-and-so, petitioner, originally defendant versus so-and-so. Address so-and-so, opponent, originally defendant. Civil revision application, not petition, it is application. Under section 115 of the CPC, claim 360 rupees. Petitioner above named most respectfully submits as under 1. And the petitioner plaintiff filed a suit in the court of civil judge with a regular civil suit. September of 2001 against the opponent defendant for possession of the suit premises on the ground of non-payment of rent and reasonable and bona fide requirement of the landlord. 2. And during the pendency of the said suit, the plaintiff made an application, exhibit number 67, under provisions of Order 6, Rule 17 of the CPC, on 5th November 2002, praying therein that for the amendment of the plaint and claimed relief of possession of the suit premises on 2 additional grounds. 1. Defendant had made permanent structures in the suit premises without prior permission of the landlord. 2. Defendant was causing nuisance and annoyance to the landlord and to other tenants and neighbors. 3. That the learned judge, after hearing both the parties, rejected the said application by an order below exhibit 67 on 27 January, holding that the amendment sought was not necessary for the purpose of determining the real question in controversy between the parties. That There was delay in making the application that the proposed amendment would change the nature of the suit and that if such amendment were granted, it would cause great prejudice to the other side. For that being agreed by the said order, below Exhibit 67, the petitioner herein approaches this Honorable Court by filing the present revision application on the following among other grounds. Grounds 1. The learned judge has erred in rejecting the application Exhibit 67 filed by the plaintiff. 2. That the learned judge ought to have granted the application Exhibit 67 filed by the plaintiff. 3. That the learned judge has erred in holding that the proposed amendment was not necessary for the purpose of determining the real question in controversy between the parties. 4. That the learned judge ought to have held that the proposed amendment was necessary for the purpose of determining the real question in controversy between the parties. 5. That the learned judge has erred in holding that there was delay on the part of the plaintiff in making application 67. 6. That the learned judge ought to have held that there was no delay on the part of the plaintiff in making for application for the amendment. 7. That the learned judge ought to have appreciated the fact that both the grounds mentioned in the application for amendment Exhibit 67 had arisen after the filing of the suit and therefore they could not have been included in the plaint. 8. As a learned judge, having erred in holding that the proposed amendment would change the nature of the suit. And the learned judge ought to have held that the proposed amendment would not change the nature of such suit enhancements as the suit was for possession of the suit premises and even after the proposed amendment, nature of the suit and relief claim would remain the same. 10. That the learned judge ought to have appreciated the material fact that the addition of some grounds for possession of the suit premises, the nature of the suit can never be changed. 11. That the judge has erred in not considering the fact that the proposed amendment was necessary to avoid multiplicity of suits. 12. That the judge ought to have appreciated the fact that by the proposed amendment would not annul injustice to the defendant and therefore ought not to have exercised the discretion by granting it. That the learned judge ought to have construed the provision relating to amendment of pleading liberally and ought to have granted the application for amendment. 14. That the learned judge, in rejecting the application for amendment, has acted in breach of the provisions embodied in Order 6, Rule 17 of CPC and thereby acted illegally and with material irregularity. 15. That had the order been made in favor of the petitioner, it would have finally disposed of the suit or other proceedings. Next, there had been order made in favor of the petitioner, it would have finally disposed of the suit. Next, that even otherwise also the order passed by the learned judge is illegal, erroneous, against principles of natural justice, equity, and good conscience. And same requires to be said. Next, on the grounds stated above and on the grounds which may be urged in the Time of hearing, it is prayed that this revision application may kindly be allowed in the order below 67. Exhibit dated 27 January, passed by civil judge, and the regular civil suit number 34/2000 may be set aside and the application for amendment may be allowed. That any other relief of court may think may also be granted. For this act of kindness, the petitioner shall, having duty bound, forever pray. Next, Appendix G, injunction application. In the civil court, Hyderabad, 100 of 2002, so and so, Hindu adult age 50, address plaintiff, so and so, age 55, Hindu adult, address so and so, defendant. 1. The plaintiff above named humbly states as under 1. That by an agreement in writing, dated 1st January 2001, signed by the defendant, that defendant contracted to sell to the plaintiff by Bangalore, referred to in said agreement, called said property, to first that 10 lakhs. The amount of 1 lakh was paid to the plaintiff and defendant in earnest money at the time of agreement. Second, plaintiff was and is ready to and willing to perform as part of the contract, but the defendant has refused to execute a said deed and thus has failed to perform as part of the contract. 3. Plaintiff has filed the above suit against the defendant for specific performance of the contract, which is pending in the honorable court. The plaintiff has the term of the case and the balance of convenience is also in his favor. The plaintiff has come to know that the defendant is trying to dispose of the suit property and has contracted some parties for the disposal. The plaintiff admits that if the defendant is not restrained from disposing of in said manner, transferring the said property during pendency of that suit, irreparable injury and loss could be caused to the plaintiff which would not be compensated. N.